From the roundtable at Uncle's Studios in beautiful Southern California, welcome to another edition of Work Comp Matters, the central location for all you employees, employers, and independent contractors. My name is Steve Appel, and I'll be your host for the next hour with some talk, news, and hopefully some answers about Work Comp Matters. Thanks for being part of the show, and if you can give us a call and break away from your Work Comp Matters, the phone number is 818-357-4120. You can send me an email to wcexaminer@aol.com. You can be old school, send a fax, 818-475-1437. With me in studio, my protege, attorney Robert Ozeron. Scott Walton of Uncle's Studios is on the board. Mike Burton, structured settlement extraordinaire, is in studio. Back in Munich, Germany, attorney John Scalia. And back at Work Comp Central, making sure the whole damn thing goes right, is Jake Paris. Well, good evening, everybody, and welcome to another edition of Work Comp Matters. We are talking structured settlements, and we have Mike Burton as special guest on the show. But before we get to our special guest, we got a letter last week, and this letter came to me by fax, which I find fascinating because I constantly get asked, in this day and age, why do you continue to list the fax number? I mean, people use email and people use text, but why do you keep saying the fax? And of course, the first letter that we get to the show comes to by way of fax. So this is why. The letter is anonymous. That's number one. No name, no phone number. It says, "Attention, Steve Appel." It says, "Tell Ted Durden to buy a new suit. Best dressed. Are independent hearing representatives or contractors under the law? Can you tell Ted Durden to pay rep fees he owes bunch? Reps did work for him. Can he be sued? Why is Ted the best dressed in workers' compensation?" Well, firstly, those are a lot of questions. Thank you very much. Next, why is Ted the best dressed man? Well, I've said that on the show before. I've known Ted for over 20 years. He's a gentleman. He's a professional. He's a scholar. I met him on the phone. When I first saw him, in court, he was dressed in a two-piece dark suit, handkerchief, white shirt, red or blue tie, dressed like a friggin' politician. And every time I've seen him in court or during Monday through Friday, without question, on a regular basis, he is dressed better than anybody regularly I have ever seen. Now, believe me, I make no bones about it. I'm one of the crappiest dressers there are. I mean, it just takes the life out of me if I'm Monday through Thursday and I have to go to court. I put on a pair of slacks, a shirt, a tie, and a coat, and I look somewhat professional, but nothing compared to Ted. Why is Ted the best dressed man? Because on a regular basis for 20 years, he's dressed better than anybody I've ever seen. That's number one. Number two, I don't know if Ted owes you money or not, but if he does, you're certainly barking up the wrong tree by asking me, why doesn't he pay you? I say you go directly to the man. I would presume that if he owes you money, you at least got his phone number, his fax number, his email, some way to contact him, and you can ask him yourself. Ted has always been honest with me, and his account is square with me. Next, are hearing reps independent contractors or employees? Well, it really depends on what type of arrangement you have. I can certainly refer you to the Borello case, and I believe that's Borello. It's a District Court of Appeals case, California. It's still good, and it gives what's known as the Borello factors that talk about how you judge each individual circumstance with whether or not someone is an independent contractor or an employee. And let me close by saying this. Someone at the same time, like me, can be an independent contractor with one party and be an employee with another party, but also an employer with another party. It depends on the relationship that you have. I want to thank you very much, Mr. or Ms. Anonymous, for sending me an old school fax to 818-475-1437. I will read anything on this show, regardless of how smart or totally ridiculous it is. And if you want to give me a first name, a last name, a phone number, or just be anonymous, I'm going to answer it. And that's all I have to say about that.
You know, boss, we could probably find out who sent that fax by back tracing the fax number on the top there through.
Well, I actually have the fax number. I have eFax, and it shows what number it was faxed from. But I'm not going to talk about that on the show. I mean, clearly the sender wanted it to be anonymous. So I'm not going to talk about the fax number that it came from. I'm not going to talk about the skip trace that we did. I'm not going to talk about the names and potential locations that came up. It's an anonymous fax, and I
So you're
respect
saying they're
that.
outside their house right now, is what you're saying?
I'm saying that when it comes to this show, I am the consummate journalist. We do not have fake news. We do not suppose. It's anonymous. I have thoughts. I talked to Ted. We did an independent investigation. I could spend 15 minutes on what I think, but the bottom line, the factual point is, it's anonymous. Well, enough of that stuff. I've got a guest sitting across from me that's been patiently waiting, and I want to thank him very much for coming on. He is currently with Ringler and Associates. For those of you that don't know, Ringler and Associates helped design more than 228,000 settlement plans with premiums in excess of $33 billion since 1975. Ringlers and Associates has participated in more than one-third of all structured settlements successfully completed in the United States in 2015, and Ringler and Associates employs 150 highly skilled and widely respected advisors in 70 cities nationwide. My guest specializes. He is a certified structured settlement consultant. He is a Medicare set-aside specialist. He has a Bachelor of Arts degree in political science, summa cum laude from, I'm not even going to, he'll pronounce that university that he comes from. Susquehanna. Thank you very much. He is a member of the National Structured Settlement Trade Organization and the National Alliance of Medicare Set-Aside Professionals. He was a litigation specialist at CNA Insurance from 1990 to 1996. He was a structured settlement or a structured broker at the Pension Company, 1997 to 2006. He was a structured broker, Selective Settlements International, 2006 to 2012. He was a structure broker, Gallagher Settlements, in 2012 to 2017. He is married with 2 children. It is my privilege and my pleasure to welcome to the show Michael Burton.
Thank you very much, Steve.
It is my pleasure. I always do my best to take the Johnny Carson rather than the David Letterman point of view. If you don't know, Johnny Carson always did his best to make his guests look better, and that way I look like a stud. David Letterman, on the other hand, tried to embarrass his guests, and I don't know if he came out embarrassed or not. How's it going? Thanks for coming in to Work Comp Matters. How do you like Uncle's Studios?
This is terrific, and I really appreciate the invite. Coming up from San Juan Capistrano, the traffic was miserable, as you can imagine, but I spend quite a bit of time up near Van Nuys at the Work Comp Board, so today was no different. And so I appreciate the opportunity to stay here a little later and maybe let traffic die down for my commute back home.
You are more than welcome after the show to come out for some appetizers and drinks. It would be my pleasure.
One thing I did want to point out, just as a plug for Ringler and Associates, is that you mentioned that we're involved in over a third of all structured settlements done throughout the industry. That's still going on every year. You mentioned 2015, but pretty much every year our firm across the country is involved in more structured settlements than any other firm out there.
What I want to know is how the heck do I get onto Ringler Radio, baby?
You know, I wish I knew the answer to that, but I'll be more than happy to get you an invite somehow.
We've spoken about that before. In fact, when I was starting WorkComp Matters, Robert, you don't know this, but when I was working out the deal with WorkComp Central, I was talking to them about a budget, and I said my buddy is a structured settlement guy in the company he works for has got like a podcast radio thing, and this is how much their costs are. I can do it for a considerably better rate, and I wanted to say, like, you help me negotiate my deal, whether or not you know it.
Well, the best part about that is I haven't been invited on Ringler Radio yet either, so we'll make sure that we try to get that done sooner than later.
That sounds like a great idea. So I read your bio. When did you actually go from claims or investigation to doing structured settlements?
It's a funny question. I was working at CNA, doing litigated cases and working as a claims rep. But at CNA, they own their own life insurance company, and so they had what was considered benefit settlement options, BSO program, and they were looking for their claims people to make referrals to do what are considered structured settlements. In other words, periodic payment plans to settle out their claims. And I kind of found out that I had an affinity for the financial end of the claims process, evaluating cases, but also using the tool to point out to the claimants the benefits of setting up a prepayment plan for their future medical needs or their future indemnity settlements. And so while I was at CNA, the pension company approached me about possibly being a West Coast broker for them because they were primarily a Northeast operation.
You had never expressed any interest at all. They just came to you. It fell in your lap all of a sudden one day.
I wouldn't say it fell in my lap. What happened was I was at a settlement conference and I was discussing it with the attorneys that were there, and there happened to be a structured settlement broker there, and he mentioned to me that he thought I would be good in this role.
Why?
Probably because
you must have done something.
Yeah, I guess, the gift of gab, being able to explain the terms, being able to point out the benefits of the structured settlement, things of that nature, not having been a structured consultant, but really just being a claims adjuster, he thought it would be a natural for me to move on to the next role.
Were you trying to to settle that claim by structure at that time, or did you not care?
No, I was for sure trying to settle that claim with a structure.
Why? Does it save the insurance company money? I would assume it does.
Well, yes and no. This was the debate that Robert and I were having before I came in here.
We're going to get to that in a moment. But finish off. We're going to get to that in a moment. But finish off. Why did you want that claim to be settled by structure rather than just a one-time payout?
The particular case that we were dealing with was involving a lot of future medical. And for me as a claims adjuster at the time, if a claimant was claiming to have a lot of future medical needs, financial needs in the future, be it surgeries, ongoing medical expenses each month with prescription medical costs or whatnot, but then they demanded it all be paid as cash, it always raised a red flag to me because...
You mean he might go to Vegas and put it all on 19 or 17 black on the roulette You mean wheel? He might go to Vegas and put it all on 19 or 17 black on the roulette wheel? But really what I was more concerned about, and again, coming from the defense side on this aspect, was saying, wait a second, if you're right now incurring $1,000 a month in medical costs, and you know you're going to have that for the rest of your life, and an annuity is the only product out there that a financial advisor could give you that you can never outlive. And let me repeat that again. The annuity is the only product out there they can never outlive. So if they're concerned about their future medical, option A would be never to do a CNR, because this way they leave open future medical and they can hopefully count on the defense insurance carrier to take care of them. We all know that there's a debate that's been going on for a long time as to whether or not claims adjusters are taking good care of these claimants. And the people want to get out of the system, so they want some freedom, they want some independence, they want to be able to manage the money themselves, go to get their pharmaceutical drugs when they need it, or go see the doctor when they need it, not have to go through UR and all this other stuff.
Back then, we didn't have those same issues, but those same thoughts were in my head as to, well, if this claimant is really that concerned about making sure they have the money they need for the rest of their lives, then the annuity is going to be their best way to protect them.
Now, you mentioned earlier about Robert, and Robert is applicant attorney, 5.5, 6 years. We haven't talked about it on the show, but I know.
Well, I'm
off
learning
the
more
air-
about it actually outside,
okay.
and I'm hopefully, you never know.
Well, okay. Well, let's figure that you talk to some applicant attorney who says, I can set my client up with a financial advisor, and they can make the money more profitable. We've talked on this show about Amazon.com. We've talked about
Well, that's
blue
different than
chip
the
stocks.
investments. That's not the structure that we're currently discussing. That's just more
isn't
about
it-
investing your
No,
proceeds later.
but when you go to a structured settlement and you put it in an annuity, those funds are being invested, at least partially, in the blue chip stocks.
Well, I
Isn't
think
that true?
we're about to get illuminated, I think.
Well, illuminate us, baby.
Yeah, actually, they're not. So the illumination is that the structured settlement industry is governed very strictly, and so we are only allowed to place the annuities with, A-rated life companies out there, and those life companies are providing a fixed income guaranteed stream of payments that's tax-free to the injured worker. A lot of that is governed by different sections of the Internal Revenue Code, such as 104A, that allows for that in personal injury cases as well as work comp cases. So this misunderstanding that this is some kind of an investment vehicle, it's not. What it is basically a prepayment plan that we can tailor to the claimant's needs, and it is only being able to be done as part of the compromise and release agreement. It has to be done prior to you getting an order approving CNR, and it can only be done with a life company. So it is both a defense vehicle, by which early on you mentioned, does the defense try to save money with this? Yes. If you get a Medicare set-aside report that states that the future medical is $100,000, that Medicare set-aside is not stating that that's $100,000 in medical needs tomorrow. It's stating its needs over a life expectancy. That life expectancy may be 10 years, could be 30 years, whatever, depending upon the claimant's age. What we have shown the insurance carriers and the defense insurance attorneys and the adjusters is that, why give $100,000 cash to this claimant now and expect that they're going to be able to manage that money and not blow through it? And also, they're going to have to prepay that down. They're going to have to spend through that entire $100,000 before Medicare would ever get involved, as opposed to setting up a payment plan over their life expectancy according to what the Center for Medicare and Medicaid Services might issue in their approval letter, or just the guidelines in the Medicare set-aside report. And then this way, there's a savings to the insurance carrier as to the present value cost of that annuity to fund the MSA. But it also protects the claimant because those payments are going to come in each year. And this way, if they spend through that in one calendar year, at least the next year they know another payment's coming through. Also, if they spend through it properly, then Medicare becomes primary for the remainder of that year. As Robert and I were starting to debate earlier before we got on the show, because he said that he's always demanding a lump sum. And I asked him why. And he said, well, because it's better for my clients. That's what they want. I said, sure, in theory, most claimants want cash. They all want cash. But as I was speaking earlier, is on the future medical, that's what this money is really for. It's for their protection, for their future medical, to make sure they don't run out of it. And a lot of applicant attorneys, like Robert, and not to hang you out to dry, but he mentioned, hey, it's my job to get them this money today and worry about today. I'm not worried about tomorrow. Well, the reality is that's my job. My job is I'm a post-settlement worrier. I want to make sure these claimants are taken care of 5, 10, 15 years down the road. So I want to take the money that the defense is willing to offer you and your clients and put it in the light most favorable to your claimant. And that's what the benefit of the structure is to protect them down the road. Now, as far as who saves the money, sure, if we can structure that $100,000 MSA for $50,000 or $60,000 cost, and that delta, the $40,000 savings, If the insurance carrier wants to say, we're only going to offer you the structure, we're only going to be willing to fund it with that present value cost, then you got to negotiate the other aspects of it, the value of the indemnity, the value of the non-Medicare related medical or whatnot. Because just like I would be telling the defense, why would you give them $100,000 to fund an MSA that you can structure for $60,000? You might also be saying, well, wait a second, if I'm going to accept the payments over the rest of their life versus getting it as a lump sum now, I want to get a little bit of cash as an incentive to my client to do that. So that's where the negotiation comes in.
I know that one of the questions you're constantly asked is, what exactly is a Ringler settlement plan? So what is a Ringler settlement plan?
Well, we like to think of ourselves as a one-stop shop. You know, it's funny because a lot of times I get calls from defense attorneys or applicant attorneys or claims adjusters that say, hey, can I get a quote? And quite frankly, providing an annuity quote is the simplest part of our job. The most difficult part of our job is applying the various different types of annuities to your given scenario, be it whether you have a death claim or you have a perm total case or you have a case that's a lower disability, or maybe you just have a future medical case. So in essence, as I was talking about earlier, is an annuity is a prepayment plan basically set up through the life company that we establish, but we're only governed by the creativity that you and I might come up with.
And I was going to say, and that's probably the difference between an annuity and a structured settlement. An annuity is where the money sits, but a structure is based on your creativity with the defense attorney and the applicant attorneys and how the money is dispersed. Do I have that correct?
Yeah, the annuity is the vehicle.
It's one part of a possible structure.
Yeah, the annuity, you hit the nail on the head.
The annuity would be the vehicle and the structure is the road. Which road is the vehicle going to go down?
Well, the term structured settlement can encompass both cash.
It's like New England. It's a region.
Exactly. It's both cash and the annuity. And so, again, there's this understanding or this misunderstanding by people when they say structured settlement. Well, I want either a lump sum or structured settlement. Hold on one second. There's no situation in which you're going to do a compromise and release where the entire settlement is going to be structured. You're going to have cash up front, typically for attorney's fees, or you're going to have cash up front for the Medicare set-aside seed money if there's an MSA involved, or the claimant themselves is going to want some bit of cash up front to just put into their bank account, maybe part of their indemnity settlement. Maybe they want to take all of their indemnity as cash. The annuity is that portion of it that they're not going to get in cash that's going to be placed with a life company that's going to be paid out to them in intervals into the future.
Now, what happens upon their death? Is this their money? It's vested. Does it go to their family if they were to die suddenly?
That's written into the structure, right?
Well, it all depends on the kind of annuity. There are temporary life annuities, there's life annuities, and there's annuity certains. There's various different types of annuities.
And I've done a structure with you where we had like 10 years guaranteed and then paid out for X amount of years afterwards. It just depends what you write into it.
Exactly. It's all about the negotiation. Again, typically when we do the Medicare set-aside annuities, because that's money that nobody views as a windfall or something that claimants would ever have to give to their family, a lot of times those are done as temporary life. In other words, it pays to them as long as they're alive for a fixed period of time. Now, once they get the money, and they put it in their own bank account, that is theirs. And if there's any money left in that bank account when they pass away, that would go to whomever they designate as a beneficiary or their estate.
Now, if they put that money in an interest-bearing account and they earn interest, is the interest taxable?
Once they have constructive receipt of the money, whatever they do with it, any interest they earn is taxable. However, the interest earned on the annuity prior to them getting paid it is tax-free.
Now, I know the last time that I called you on one of my cases, I had the defense that I took the case in, I subbed in, and they already had a structure going with their own structure company. but I decided to call you. And not only did you say that you knew the structure guy that set it up, but you could probably contact him on my behalf and get a little bit of a better deal. And not only did you get me a better deal, I'm assuming you made some money for yourself and you made the defendants happy because the whole deal closed. How did you do that? Or when a structure is already set up by the defense, how do you come in as the new guy and say, okay, I'm representing the applicant now, we can get him a little bit better money?
That's a great question because, again, everybody needs representation. And so, there are people out there that focus mainly their business on applicant attorneys and the applicant side of the business, and those that focus mainly on the defense side of the business.
I like you, baby. You work both sides of the street. I know that.
Quite frankly, I started out primarily doing defense work, but as I was going to various different settlement conferences, mediations, what have you, I was very fortunate. Guys like yourself were impressed by the job that I did, and then they'd reach back out to me. There are certain insurance carriers out there that don't like to see you come in against them, so to speak, on with an applicant attorney when they've been doing business with you on the defense. But I've been pretty successful in explaining to them that this is a close-knit marketplace out here. We all know each other very well. We have a lot of professional respect for one another and professional courtesy. So in the situation that you were talking about, a lot of times, if I can find out who the defense attorney is or who the insurance carrier adjuster is, or if they have their own structure person, like you said, I can make a phone call to them and find out some information that they might not feel comfortable giving to you.
And, of course, when I called you, you basically said, Steve, no obligation. It's not going to cost you a dime. I'll take a look at it. If I can't do anything, we'll do it on the next one. But you were able to do something, and you got my client more money, and presumably you made a little bit for yourself, and obviously you made my boss a little bit more money as well.
Well, part of the key is that we all do get our numbers from the same places. There's 7, 8 life companies. It all depends upon the different carrier that you're dealing with. Maybe you're not going to be able to use every life market. It also depends on the date of injury. But having said that, it's a bit of a dummy in, dummy out. If you're only looking at 2 or 3 different life markets and you're not looking at all the different options out there, then you don't know what you don't know. And so what I try to bring to the table is the breadth of my experience. I've been doing this for 25 years, and looking at the case from a claims background as well as some bit of a legal background, and also analyzing the data and then trying to give you something better than you'd get by just plugging numbers in.
And that's why you're on the show. My name is Steve Appel. You're listening to Work Comp Matters. We're talking with our special guest, Mike Burton from Ringler Associates, on structured settlements. As always, we're brought to you by A1 Law and Santa Monica Tickets. If you want the #1 computer management system used by more workers' compensation attorneys than any other system on the planet, give me a call at 818-357-4120 for your no-strings-attached money-back guarantee. $1 a day. A1 Law. And if you want those hard-to-get sold out, even front row concert, sports, and theater tickets, give our buddy Brian a call at Santa Monica Tickets, 310-395-8587. We'll be back after our first musical break. He's La Familia, he's Glenn Laughlin, he's the Cherry Blue Storms, and baby, you're a rich man.
How does it feel to be one of the beautiful people? Now that you know who you are, what do you want to be? And have you traveled very far, far as the eye can see? Baby, you're a rich man. Baby, you're a rich man too. You keep all your money in a big brown bag inside a zoo. What a thing to do. How does it feel to be one of the beautiful people? How often have you been there? Often enough to know. What did you see when you were there? Nothing that doesn't show. Baby, you're a rich man. Baby, you're a rich man too. You keep all your money in a big brown bag inside a zoo. What a thing to do. man. Maybe you're a rich man too. How does it feel to be one of the beautiful people?
Glenn Lachlan and the Cherry Blue Storms, Baby You're a Rich Man on Work Comp Matters. We're brought to you by A1 Law and Santa Monica Tickets. If you want the #1 computer management system used by more workers' compensation attorneys than any other system on the planet, give me a call at 818-357-4120 for your no-strings-attached money-back guarantee, $1 a day, A1 Law. And if you want those hard-to-get, sold-out, and even front-row concert, sports, and theater tickets, give our buddy Brian a call at Santa Monica Tickets, 310-395-8587. We'll get back to our special guest, Mike Burton of Ringler and Associates, talking about structured settlements. But it's time for a little news break with the first story. He's my protege. He's a 6-year applicant attorney. He is Robert Ozeron.
Well, thank you, boss. And the lead news story, the only news story for the city of Los Angeles as far as a lot of people are concerned, LeBron James has signed a 4-year, $154 million contract with your Los Angeles Lakers, baby. Yes, King James has arrived.
And the 4th year is optional, and I'm hoping that he's going to give back that some of that salary to bring on a support person or whatever. But you know far more about it than me, my boy.
For the amount of happiness he's already brought the city of LA, it's already paid for itself.
With the second news story, I will read that about $2 billion in funding approved by the state legislature of California to provide housing for the homeless people with mental illness has been stalled by a legal challenge. In an attempt to bypass the lawsuit, Governor Jerry Brown and legislators have agreed to bring the issue to voters in November.
California lawmakers passed a 12-year ban on cities and counties from imposing more taxes on soda. However, major healthcare groups announced Monday that they will pursue a statewide soda tax initiative on the 2020 ballot to pay for public health programs.
Silver Lake Medical Center, which operates a 118-bed psychiatric facility and is suspected of discharging hundreds of homeless patients and dumping them at bus and train stations instead of shelters or other facilities, has agreed to pay a $550,000 legal settlement, according to City Attorney Mike Fuhrer.
California Corrections Department is spending $46,000 a month to buy bottled water for inmates and staff at a prison in Tracy, where it opened a state-of-the-art water treatment plant 8 years ago. Dual Vocational Institution draws waters from Backish wells on its grounds and runs it through a 2-step treatment process before providing it to 2,300 inmates and 1,000 employees for drinking or for showers. I know we have a story on Tesla. Do one of you guys want to read that?
Well, I didn't understand that story, though, because they're buying bottled water even though they had previously paid for a treatment facility.
And it also seems to me, and I could be wrong, that these inmates, what they do for jobs at 15 cents an hour or whatever it is they process water. So they're bringing them in bottled water to drink because the job that they do is recycle water. I don't quite get it.
It sounds very California-like. Whatever it is. It sounds perfect for us.
Where's the Tesla story?
I think I've got it here.
Okay, go for it.
Tesla produced 5,031 Model 3s in the last week of the second quarter and expects to make 6,000 per week by late next month. The Model 3 had missed 2 production targets, but Musk, I assume you mean Elon Musk, had promised investors that the company would make 5,000 Model 3s per week by about this time last year.
Up to 30% of teenage girls in some part of the United States say they have intentionally injured themselves without aiming to commit suicide, which researchers have found. About 1 in 4 adolescent girls deliberately cut or burn themselves compared to 1 in 10 boys, according to Martin Monto, a sociologist at the University of Portland and lead author of this new research.
And for the last news story of the show, I've got it. Yelp cannot be ordered to remove posts criticizing a San Francisco law firm, even posting that a judge determined were defamatory. The California Supreme Court has ruled. Some had worried the case's outcome would silence online speech. I don't think anything is going to silence online speech.
Not hardly.
Yeah. And speaking of internet, how has the internet, Mike, changed or altered your job at all?
Well, I can remember the first time I ever got an email way back when. And personally, whoever invented the email should be shot, only from the standpoint of now I get literally hundreds of emails every day.
How many of them are spam?
No, I'm talking about literally hundreds of emails work related.
Really?
I probably get 100 spam an hour, but
My goodness.
But what the trend has been that my phone almost never rings anymore. I virtually never get phone calls. I almost always am getting emails. And the problem now with technology is that everybody thinks that we're available 24/7, no matter what. So,
Instant gratification.
exactly. And we are beholden to these new smartphones, and I'm not so sure how smart they are, because now, as a structured settlement broker, and as you alluded to early on, I'm an independent contractor, even though I'm part of the association.
I took an educated guess.
I'm part of Ringler Associates, and it's a phenomenal group, but we eat what we kill. And so therefore you need to be available.
So do they at least give you a draw?
No.
Okay, so clearly you're not on salary, and now I found out they don't give you a draw. You eat what you kill.
Well, listen, I'm an associate, so I've been in the business long enough. I produce my own amount of business, and so I take care of myself. However, the way Ringler is, and we believe we're the best in the business, I believe we're the best in the business, we take care of our people. So again, we don't just bring in people without any kind of education or experience and not give them a draw and expect them to go out there and earn. Typically, the way our company is set up is that we bring in people to work underneath an associate or in tandem with an associate, and we would give those people a draw, take care of their expenses, and try to get them up and running.
Now, I know you have an assistant, but you mentioned bringing in new people. What are you looking for in a new person to come into your industry?
Well, quite frankly, if it was for me, I would be looking for somebody younger and more energetic, kind of reminding myself of my...
Well, are you looking for like an accounting investment background, or are you looking for an insurance background or a work comp background? Or
That's a great question. It helps to have a claims background for sure. Certainly, because my business is quite predominantly work comp related, it's very helpful to understand the lingo and the technology and how to deal with AIMS forms and know the difference between TTD and PD and things of that nature. But it's not absolutely necessary. Quite frankly, early on, I had to educate myself in a lot of these things because I had a broad background. I worked as a TPA before I went over to CNA. And so, whether you're coming out of college right away with an education background in accounting or economics or whatever, or you've been in the industry as an adjuster, what you really need is just a willingness to understand it. It's going to take you 2 to 3 years to build up a book of business. If you come out as a structured broker now, you've got to get to know the business itself from the technical side. And you need to get out there and market yourself to the lawyers and the claims people.
So how did you first market yourself? I mean, you told us the story about how you got into it. Once you got into it, how did you attract new business? Hell, I don't even remember the first time I communicated with you.
Well, it's funny. When I first started out, I was told, don't worry about or bother calling on all the people that you knew at your old employment because they'll never give you any business.
That is such a defeatist attitude. That reminds me of like when I was in college and I was in my broadcasting class, and the first thing that my professor said to all of us on day one is, if you're looking for a career in radio, forget it. There are no jobs available.
Well, mine goes even a step further. My background was actually in liability claims, and so I had a very limited exposure to work comp. However, when I got involved back in the mid-90s, I saw an opportunity in work comp, and I thought that work comp was the future of structured settlements, at least for me, because there were a lot of structure brokers in Southern California that were handling medical malpractice and liability claims, and I thought it was going to be more difficult to get into that space. And my new bosses told me work comp's a waste of time. Don't go after that. You'll never get anywhere with that. And I said, well, I got to keep knocking on doors. I got to go into every claims office, call on everybody. And of course, back then we were able to get into these offices. Nowadays, because so many people are working out of their homes, there's telecommuters, all that, it's more difficult.
Good point.
So it is definitely much more difficult for somebody new into the industry now to get to know people versus back then. I was able to go into all these offices and at least introduce myself. And that's what I did. And I just, every single day, I called on somebody, called new. I pulled up, the yellow pages, really, and just looked up different insurance carriers and called up managers, claims adjusters. And I figured if I made 100 phone calls and I was able to get 5 people to literally speak to me and I could get one meeting, I was actually getting somewhere.
100 phone calls in one day, and you make one new potential client you can get in the door, and that's all you would look for is one potential client a day. I think that's awesome. My name is Steve Appel. You're listening to Work Comp Matters. My special guest is Mike Burton with Ringler & Associates. We're talking structured settlements. We're brought to you by A1 Law and Santa Monica Tickets. If you want the #1 computer management system used by more workers' compensation attorneys than any other system on the planet, give me a call at 818-357-4120 for your no-strings-attached money-back guarantee, $1 a day, A1 Law. And if you want those hard-to-get, sold-out concerts, sports, theater tickets, give our buddy Brian a call at Santa Monica Tickets, 310-395-8587. We'll be back with our special guest, Mike Burton, talking about structured settlements after our last musical break.
I sold my soul, I can't get it back. I've fallen down on my lonely track. Something inside is dying to break free. I got chains wings to be. I long to break free from this lonesome jubilee. I feel so scarred and scarred by this party's policy. Yeah. If I could change my ways, baby, I would change today. I got chains, wings used to be. Going high up in the sky. Don't worry, my life ain't gonna pass me by. It's the end of the road, my lonely road, a dreams untold. I got chains, wings used to be. And just the other night, I found myself talking philosophy. I've learned you gotta keep changing. Take it from me.
Susan Scheller on Work Comp Matters. My name is Steve Appel, brought to you by A1 Law and Santa Monica Tickets. If you want the #1 computer management system used by more workers' compensation attorneys, give me a call at 818-357-4120 for your no-strings-attached money-back guarantee, $1 a day, A1 Law. And if you want those hard-to-get, sold-out, front-row concert sports theater tickets, give our buddy Brian a call at Santa Monica Tickets, 310-395-8587. My special guest is Mike Burton, structured settlement representative from Ringler and Associates.
Just one little correction. We dropped the "and," so it's just Ringler Associates.
Oh, no, thank you. No. That is extremely important. Absolutely.
Above my pay grade as to why they did that, but just pointing it out.
Thank you very much. We already talked about the differences between an annuity and a structured settlement. Could I do better using outside investments? And if so, I'm assuming it's probably a lot more riskier and might not even be approved by the judge, right?
Well, it's certainly going to be riskier, and it all depends on the type of case you have. For example, in liability cases involving minor children, the judge is not going to approve it. They're going to either request that you put it into a blocked account, and it's going to be maybe in a money market, maybe a bond fund, maybe, or do a structured settlement, because they want to make sure that money is secure and there can't be any dip in it as far as underperforming. Now, having said that, when I'm dealing with minor cases, I always tell the families, would you really want, because I have an 18-year-old son and I have a 21-year-old son, and would you really want your 18-year-old son to get control of all their money? Whether it's $20,000 or it's $200,000, would you want them to have access to that money on their 18th birthday? I think unequivocally most people would say no way.
Let's get right down to it. What's the largest structure you've ever done? I'm thinking $10 million. Hold on, Robert, what do you think?
Well, I didn't think about it ahead of time, but I'll say 5.
Do you mean the annuity or the actual settlement?
You tell me.
Well, recently, I actually did an annuity that was about $5 million, and that on my own was the largest that I was involved with. However, when I say on my own, there was another broker on the other side of that case. It's very rare, if almost never happens anymore, where there's not multiple brokers involved when there's a 7-figure annuity going on.
Okay, so you just said a $5 million annuity. Does that mean that $5 million of hard cash goes into the annuity, and then clearly more than that is paid out over the life of the structure? Is that correct?
Correct.
Okay. How much money did that produce over the life of the structure?
Almost double that.
Oh, right, exactly. Now, is it true that do we still practice that money doubles every 7 years in this type of industry?
Not in our industry, because right now, first of all, you have to understand we're dealing with fixed income annuities, so very low rate of return. We're not out there selling a rate of return. We're not trying to compete against a certified financial
You're
planner.
selling security and safety.
Exactly. And so, again, that's when Robert was mentioning early on about investment. I said, you got to get the word investment out of your vocabulary when you're talking about a structured settlement, because investment to me connotes that you're going to take that money, maybe put it in the stock market, maybe put it into real estate, maybe do some other things, but it's not money you need right away, and you're willing to bear some risk out there. The structured settlement is geared towards these claimants that need this money on periodic payment plan that's going to meet certain intervals of needs, whether it's a monthly need for lost income or whether it's a surgery out in the future that they need to know they got
or
that money.
Or a combination of both.
Correct. Well, it's usually always a combination of both, but sometimes not. And so trying to compare the performance of a structured settlement, the annuity, versus what you might get if you invested the money in Amazon or
Some
Apple.
sort of an open market investment.
It's apples and oranges. Again, if you're dealing with some middle-aged man who's still working, who happened to walk through a crosswalk, got hit by a car, broke his leg, going to get a few $100,000, but he doesn't need that money, and he wants to take that money and go invest it in the stock market, God bless him. But that's not what we're dealing with. What we're dealing with is maybe the guy that doesn't have a job, and that money is the only money he's going to be able to live off of, or it needs to at least subsidize part of what his future medical needs are going to be.
Mike, what if any discussions do you have regarding Medicare and Medicare set-asides and Medicare set-aside approvals?
Well, almost every day, almost every case. Nowadays, that first of all has to be taken into consideration. Medicare is a secondary payer. Per the MSP, you are required, whether it's the defense or the applicant side, plaintiff side, they need to take into consideration Medicare's rights as a secondary payer. So at the very least, you need to find out, has the claimant applied? Are they eligible? The best way to do that is to have them sign a release form and, do a Social Security check. Once that's been checked into and we know, hey, this claimant is on Medicare or they're eligible and they're going to maybe, apply and be on Medicare in the next, year or two, I typically tell the claims adjuster or the attorney, you should get a Medicare set-aside report done. The Medicare set-aside report is the simplest way for us to demonstrate a savings on any case. Whether it's a $20,000 Medicare set-aside report or it's a $2 million Medicare set-aside report, as I stated earlier in the show, that is a snapshot of the medical over that claimant's life expectancy. It's not medical that's needed tomorrow. So by doing a structured settlement, we're going to be able to reduce that MSA down to present value and show you what it costs to pay that out over that claimant's life expectancy.
Why does it always seem like it takes so long to get the MSAs and to get the MSA approval? Why does it always seem like people are dragging their feet?
The simple answer is because people tend to drag their feet. I'd like to lie to you and tell you it's different, but there's this, again, misnomer that every time you get a structured settlement involved or you're getting an MSA involved, that all of a sudden the claim is going to take forever to resolve. If you are doing what you need to be doing and you're getting all the information you need, the Medicare set-aside report should be able to be produced by a vendor within a few days. I know vendors out there that can turn around the MSA report in a day if needed. However, they can't write that report without getting the claims payment history for the last couple of years and all the medical reports they need. Now, having said that, writing the report and getting CMS approval are two different things. So again, it's the same aspect, is that once we have an agreement to send this to CMS for approval, they need to have a valid release that's been signed, and all the proper paperwork needs to be sent by the vendor to Medicare. Most times, the reason why there are delays is because not every bit of information was sent to the Center for Medicare and Medicaid Services. Plus, keep in mind, you're dealing with the federal government. They're going to move at their pace. But I'm seeing these reports coming back and CMS approval coming back much quicker in the last year than ever before.
I know, to the best of my knowledge, I've never once seen or heard of Medicare coming after a workers' compensation insurer or a workers' compensation applicant or a workers' compensation applicant attorney saying you screwed with the MSA and now we're coming after you for money. In fact, the only case law that addresses that issue is in personal injury cases. Do you think there's ever going to be a chance where MSA is going to come and say, you did not take care of Medicare's interests, we want money from you?
The answer is yes, because you said, do I ever see? I do see there being a scenario, but the likelihood of it in the short term is not great. It's a very simple threshold to bear, and there's no requirement that you get CMS approval. So in the law, it states that you need to take reasonable steps to take into consideration.
To consider Medicare's interest. Now, and I know I interrupted you, and what I'm about to say, Robert probably is aware of. more and more on the high dollar settlements, I'm seeing defendants put in what appears to be more protective language, even going to the point where the applicant is going to not only hold the defendant harmless, but protect, indemnify, and pay if Medicare comes after the defendant. Now, me as an applicant's rep, I would never allow that language to be in a CNR. Are you seeing that language and how that the defendants are putting in, and how are the applicant attorneys responding to it?
I personally have not seen that language, and quite frankly, if you are seeing that language as an applicant attorney, you can just laugh at it, because the Center for Medicare and Medicaid Services does not acknowledge any type of hold harmless either way. Neither side
How
can
do you
hold
know
it.
that? How do you know that?
There have been letter rulings stating that. I apologize. I can't cite the specific.
No. That's okay. So,
Well, Medicare's interest is public policy, right? The only case law we have to file, as far as code, I understand, is we must keep Medicare's interest in account
Right,
during the settlement. It's very
right.
vague.
No,
Right, but what I'm saying is that Medicare will not take into consideration any hold harmless. So there's, first of all, by logical sense, they're not going to expect a claimant who doesn't have
That's
the
what I
knowledge and
figured.
expertise to hold some large insurance carrier harmless.
That to
Yeah.
me makes common sense. Even if the applicant attorney signs off saying that the applicant holds the defendant harmless, and Medicare says they want $50,000, are they going to come after an applicant who's surviving on $2,000 a month, or an insurance company that's got $250 million in the bank?
And that is in essence the reason why you're seeing delays on these cases, and some of the large insurance carriers out there, be it AIG or ACE, are requiring CMS approval because they want to make sure they've crossed every T and dotted every I, even though there are large self-insureds out there and other carriers out there that have taken the position that just merely having the Medicare set-aside written into the CNR is sufficient. And again, I can't stand in judgment and say who's right and who's wrong. All I can say is that it's your definition of reasonableness. If you've hired a vendor, you've paid good money, they've reviewed the medical reports, they've written a report, you've put that report into the compromise and release, you've gone to the extra step of funding it with a structured settlement, which is, quite frankly, CMS's approved process. They would much prefer to see structured settlements used to fund the MSAs versus a lump sum. Then you've probably taken reasonable steps. However, what can get you into trouble is if you've gotten that Medicare set-aside report or you've gotten CMS approval and then you don't settle the case until 2-3 years down the road and the medical condition of that claimant has changed dramatically. There are some adjusters, carriers that don't take the next step, which is getting an updated MSA or looking at it. Now, CMS will not re-review a Medicare set-aside report. However, there have been, I believe, letter rulings or guidance indicating that if the medical conditions have, seriously changed, you should take that into consideration. So even if you have a $100,000 MSA and it's been approved by CMS in the year 2018, but you don't settle this claim until year 2020, and this claimant's medical conditions have gotten far worse, you may need to add additional money into your settlement for that.
Now, I got a question about the value certain insurance companies give medical treatment versus the value Social Security Medicare could have at those same treatments or modalities, whatever types of treatments they provide. Do you notice any type of rift there between what the insurance company says is the stated value according to them of the medical treatment? Like, we pay insurance rates for this surgery, we're not going to pay that much, versus what Medicare wants versus, of course, the usual and customary value what the applicant attorney demands?
Well, I definitely see a wide breadth of differences, but again, it's all part of the negotiation. I mean, most insurance carriers are going to base their Medicare set aside on whatever the report came in from their vendor. And that's where, professional administration post-settlement comes into play.
I'll tell you, we're almost out of time. I got one more question to ask you. Thank you, Robert. Really briefly, what is seed money?
It's a great question. With regard to the Medicare set-aside, the seed money comprises the first 2 years of payments needed to handle the Medicare set-aside. And so usually that's paid as upfront cash to the claimant, and then the first annuity payment starts a year later. And so that's seed money is used to put into the interest-bearing bank account for them to set up, whether it's a self-administered account or they get it professionally administered. And having brought up the professional administration gives me a great suggestion to you for a next guest down the road, because I have a very good friend of mine that works for a Medicare set-aside company that is way more knowledgeable about all the specifics that Robert was getting to off the air.
I'd love to have him or her on the show. That's a great suggestion. I could talk to you for another hour, Mike.
Yeah, we learned a lot this show, huh?
Yeah, but we are out of time. For my protege, attorney Robert Ozeron, for Scott Walton of Uncle Studios, engineering on the board, for my special guest, Mike Burton of Ringler Associates, for John Scalia, attorney back in Germany, and for all the good people back at WorkComp Central that continue to approve and support of this project, including but not limited to Lee File and Jake Paris. My name is Steve Appel. We'll see you again next week for another edition of Work Comp Matters.
That was interesting.